All right, for more on that, I'm joined now by legal analyst Mpumelelo Zikalala. Good to have you, and thank you very much for your time. I tell you, for us it was higher grade, but I'm sure for you it was quite simple. Some of these issues that they were arguing there. So let's go through the various chapters and help us understand. First and foremost, for me, what stood out earlier on is this debate around motion proceedings and wherein lies the honors. Just explain to us what they were arguing there.
Basically, when you talk about motion proceedings, all the arguments which are going to be done on paper, so it has to be submitted on affidavits. Now, the shortfall, or the one thing which hinders the court in terms of being able to extract the truth, is that you can't cross-examine an affidavit. So it then says, if there's a dispute of fact between the two parties and you need someone to go into the witness box so that they're able to be interrogated, it limits the manner in which the court would have worked, and it takes away the basis of the agency, and it prolongs the matter before you find to finality. Now, the onus is then on the applicant to then say which is the best way in order to make sure that your point is able to come across in a much more coherent, much more clearer, in a way in which you'll be able to convince the court earlier as to what is the relief that you are seeking. So on that basis, that's what they were saying, in terms of saying maybe the manner in which you brought this application is going to hinder it. And it's on that basis, as the dominant leaders, Dr. Magudumana, you stand to fail in the manner in which you've approached, and you are going to linger on the essence of agency. Hence, you had the advocate stating that since April, you had an opportunity to file an application similar to this one, but you wait up until the last minute before you file it. On that alone, no matter should be dismissed because it's not urgent.
Yeah, the lawyer for Dr. Magudumana is saying, well, we didn't even put the matter of urgency in the papers because he says, I mean, there's a law that establishes that once a person says, I am illegally detained, that in itself immediately establishes urgency.
But it must be alleged in the paper. So you can't then ask the court to insinuate or read into your papers what you wanted to consider. If that was the case, then any other applicant that would go to court will leave out important information and important elements when it comes to the law that will need to be argued at a later stage. What you then do again is that you do not allow the opportunity for the respondents to argue or maybe to point out or submit evidence which is contrary to what you are alleging. So on that basis, you can't really hide behind it and say, look at the matter as it stands now, because we're incarcerated, we're dealing with the matter of extradition, look at it in much more agency eyes, allege it in your papers, go to those exact points, add elements which prove that the matter is indeed urgent, and then you'll be able to suffice. In fact, the most famous cases come to mind is the Plascon Evans rule. Because at the end of the day, whatever that you put in your affidavit must be so convincing, and the court must be able to extract those particular facts. It is able to abuse and say, this is what we are meant to be saying within that particular process. This is what we are going to extract and believe to be the truth, because it's not in conflict, or it is much more convincing than what your counterpart is giving. So if you're going to leave out important information, you are basically saying to the court, it must adjudicate your matter with that missing information at hand, and the chances of winning are going to be decreased.
Now, let's then come to some of the matters at hand. I mean, what is clear from the papers is that Dr. Magudumana is saying, I'm not even going to talk about what you guys are charging me of here in South Africa. So we are not even going to get into that particular story. In fact, the lawyer saying all these answers that are coming from the state and the police, not important at this particular point about coffins and whatnot. But what is important right now is how this process was actually carried out. And I'm here to argue that this was an extradition that is disguised as a deportation. And one of the areas that they're arguing is that once there is evidence that shows a collaboration between two states, then it's no longer a deportation, it's an extradition. According to them, if it's a deportation, it's just the Mozambican, Tanzanian government that must decide this is what we are doing. We are no longer desirable here, and you're deported back to wherever. It's not even back to South Africa, it's back to I don't know where. I mean, what is that debate there?
Now, let's take it in two instances. Firstly, it's on a balance of probabilities, the one that says, if you are granted this urgency, are you going to win the matter at a later stage? Now, that's when you have to go into the evidence in order to be able to prove where you're coming from. Now, from Dr. Makudumana's side, she will then say, yes, it was extradition disguised as deportation. The level of communication that has taken place is not one that usually takes place in this type of matters. On that basis alone, it is insinuation or there's a reasonable conclusion that indeed the South African and Tanzanian government were colluding together as to how things are supposed to be. But from the side of the state or side of government, they'll then come back and say, no, we were engaging in processes that are normal in the normal scope of things. Deportations take place on a daily or on a regular basis. They do not need any consultation or any consent in order for that person to be accepted back. You don't break any law if you escort or you are part and parcel or in the same transport as the person who was being deported. The most important thing is that what did you decide when you're in Tanzania? And if it's the Tanzanian government that took the whole decision of saying that we are deporting you back to South Africa, South Africa cannot come in and say, we're not going to accept this individual, follow another process. They simply have to say, okay, if you say that, we're going to accept one of our own, let's fly with that back to South Africa. And only once we land, it's when we are going to start with our processes. Now, on a balance of probabilities, that's where they were trying to prove. And it is one of the elements which are looked at when you're trying to check, is the matter urgent or not? Are you going to be able to suffice on a balance of probabilities? Also linked to that is the type of relief that you are looking for. In this case, she's basically saying whatever proceedings or the outcome which is going to come now is fruits of a poisonous tree. As the High Court, as you have inherent jurisdiction, take a decision of dismissing this whole matter. But from the state, they are saying, take it in isolation. Even if we're to be found that we have not executed the warrant of arrest or the arrest properly, you can't then say that we don't have merits. There's no one that needs to be accountable in the criminal matters that we have against Dr. Makudumana. She must be able to account on that one. But that can be argued at a later stage, or that can be dealt with at a later stage when all the evidence would have been brought in, when all the evidence would have been exchanged at the parties. At this stage, there's no sufficient evidence. And on what she has applied on, definitely there's no enough evidence which is able to convince the court that what they have done or what is alleged to have been done was something which is incorrect or not invalid according to the law.
Does it matter in terms of difference of process, in terms of how things are done in Tanzania and how things are done here? Maybe police in Tanzania would say, no, we did arrest her, but this is how we do it here, as opposed to what the law says must be done in South Africa.
You only have jurisdiction on the processes which are done in your country. So you may find that in Tanzania, they do things completely differently, even if you find that if they were to apply in South African law, they'll be against the provisions of the Constitution. However, what matters the most is what happened in South Africa and how did the South Africans act or behave once within the jurisdiction of this country. Whatever decision which was taken in Tanzania, we do not have any say. We do not have any power to even determine whether it was correct or incorrect. That extends to whatever negotiations which were taking place within that particular country. But where it might matter a bit is when it comes to the decision of whether to extradite or to deport. That's where maybe it would come in terms of international law. But at the end of the day, what matters the most is what are the provisions, applicable provisions in South Africa? How is it that you should protect the human rights of any individuals, even though they are accused in any matter in which is pending against them? Follow those particular rules, make sure that they are constitutionally compliant, and then everything is going to be fine. But what happens in Tanzania stays in Tanzania with no jurisdiction on it.
Have you had a chance to look at exactly what are they seeking from the courts?
The first price is then to say declare all the conduct, even the consequences of those conduct is invalid and not in line with the Constitution. The results with the implications of that is that the Dr. Makudumana will be released, and even the criminal charges that have to follow, they would also be declared as being invalid and not constitutional. Hence, they might come to a conclusion to say that we are going to acquit you or not going to proceed with this type of action because the High Court has ruled that whatever action that follows from your arrest must be regarded as being unlawful. Yeah. That's the first one. Secondly, they're basically saying, as the court, we are throwing the ball back into your court. You have inherent jurisdiction. You can simply decide which other process is okay. But what we want to remind you of is your task is to declare a conduct which has not taken place in the property. And in this case, the conduct of the police and the manner in which the South African government has acted is not consistent with the Constitution. So take an appropriate action based on that. But the reality in which I think the court is also going to consider, they will say, we can't wish away or ignore the fact that there is a pending criminal matter which is in front of the court that needs to be adjudicated. So even if we do find or reach a conclusion to saying that your manner of arrest was constitutional, we can't declare that whatever actions which are going to follow at a later stage must also be declared unconstitutional. Let that particular process run its course, allow those individuals to prosecute you, and you'll get enough and much more adequate space to defend yourself,
sure,
which may result in Dr. Magudumana being released today and be arrested within a few minutes later. And then the normal bail process will then take place, which one does as to what was the real intention of this application.
Yeah.
Is the first part of that declare the whole process of arrest and even the merits of the case, or even the case as a whole as being invalid, so that I'm then acquitted? I think the chances of that are a bit slim. I don't think the court would want to sway in that particular provision, but it was worth a try in terms if that was the real intention of the party.
It's an interesting strategy because it would I suppose be then also tested by Thabo Bester, because I would suppose they followed the same process in terms of how they were brought back into the country. He, of course, was already a convicted murderer and rapist. So how if the courts were to provide that kind of relief for Nandipha Magudumana, how would that apply in the case of Thabo Bester?
But he would have to prove that he's not really the Thabo Bester that you are looking for. Hence, the allegations which was made during bail proceedings, or the proceedings which are taking on in magistrate court, of asking the court, are you really sure that the person who's standing there is Mr. Bester? I think they do get a hint of where maybe the team was trying to go at with this particular application. But as a tester, then they said, let's try with Dr. Magudumana and see how it stands. If we're able to be successful on that one, we'll bring a similar application from Mr. Thabo Bester with an added application of saying that we are not the person that you are saying you are. What records do you have to be able to prove that this is the person that we are looking for? Which then leads to another question of saying, they've identified, or maybe there's a loophole in the manner in which we are able to keep our records of our detainees or our convicted criminals. If someone does not have an ID, why not create a special process or special registration for them, or a special docket, or an information pack that will include their DNA, their identity document, any type of identification that there is, and any type of link that says, if this person were to die or maybe would get lost, this is how we are going to identify that this is the convicted criminal that was staying in this correctional facility that now we've been able to find. So for Mr. Bester, it might be a bit difficult and a bit tedious for him to be able to go the similar route. But if it has worked for Dr. Magudumana, of which, as stated earlier, the chances are a bit slim, but they are still there. But it could even work for him, but for him to be a lot more harder, because it's the question of identity that we'll have to deal with it first.
So if indeed the court says, well, the process was not correct, and as you put it, you were not properly arrested, 2 minutes later you are now properly arrested, does it improve her chances of bail?
It depends on what then she submits as per Section 60 of the Criminal Procedure Act. Remember, when it comes to bail, the onus is changed. It's the applicant that says it's in the interest of justice that I be released on bail. So I'm going to provide you and give you all the other factors that have been there. Now, it's also going to help because she would have had, or her legal team would have had the liberty of listening to the bail judgment that was recently issued out. So whenever there were gaps, they would then come in and say, we are going to provide as much information as possible so that we're able to display to the court that it's in the interest of justice that will be released. So if we're able to say we're not going to evade any child who submitted our passport, we can even go to the police station twice a day if needs be. We don't even know the witnesses, and even if we do know the witnesses, we're not going to interfere with them. There's no public outcry which is there. Well, there are no protests which are currently going on, or we can relocate to another part of the country, so we're not going to disturb any public order. Those type of arguments may increase the chances of bail.
Yeah. What we do know coming out from that bail judgment was that this particular judge said your personal circumstances do not trump the interest of justice. How significant is that?
It is, but that must be looked at in the context of saying you can't ignore that the person is still innocent until proven guilty. That's a very important right that can't be negated. Secondly, there are provisions which are there, let's call them preventative measures, in which instances or stop measures can then be employed so that you are not able to disturb the flowing of justice, for example, witnesses being intimidated and all sorts. Hence, I couldn't understand as to why the magistrate was so harsh in that particular instance, because in 90% of the cases which go to court, the witnesses end up being known. Once the docket contents have been exchanged between the parties, you even know who's going to say what, and probably their addresses included in that affidavit that is exchanged with you. So in order to try and counter that, you then say, if I find out that you've tried to contact any of the witnesses, I'm going to revoke your bail. Those are the type of stop measures that are there, or preventative measures that are there. So if you then try and find the perfect situation where the witnesses are not going to be known, there'll be less interferences with whatever investigations that are taking place, you are not going to find a matter which is like that, which you may fail in terms of your bail application in the magistrate court, but definitely in the High Court, I'm sure they'll come back with another outcome.
Yeah. Finally, it's another matter. I don't know how significant it is to the case, but it certainly was argued. The whole question of what is South African territory, or whether the consulate or wherever the ambassador is, that is deemed as South African territory, and therefore South African law applies there. How far is that going to weigh in this debate?
It is, but depending on if you are saying that there's any South African territory in Tanzania, then the question is, what did you do within that particular, or the sequence of events that took place within the time? Are you then alleging that the arrest took place in Tanzania and South African territory, or are you alleging that the arrest took place once they landed at OR Tambo, for example? So if they landed at OR Tambo, then you're perfectly fine. The South African provisions or the Sacred Law would have applied within then. We're within our territory, and anything that needs to be applied is applied for in a proper manner. But if it is done in Tanzania, then you have to apply those extradition rules, because what you are then saying to the person is that I'm going to try you when we get back at home. So there needs to be that reassurance of saying that if you are going to go and try me, even though I'm a South African citizen, please give me the assurance that I'm going to have a right to legal representation, my rights are going to be protected, I'm not going to be subjected to a death penalty, even though there's common cause. But allow the process to run first in Tanzania, and then when we come to South Africa, that process is going to run. So it's going to be important if there are any allegations, but most importantly, when was she told that she is now under arrest, and when was she told that we are now reading your rights? That's going to be very important as to when did the arrest actually take place, and the type of consequences and things that ought to be followed after that.
Now we know that the matter of the other gentlemen who were denied bail, and those who have been given bail, and Mr. Thabo Bester as well, is now due for later this month of June. Is this process likely going to delay that, depending on what the outcome is?
Not necessarily. They run concurrently. Remember that when it comes to bail proceedings, we're only looking at the interest of justice. Are you going to be tried? If we release you, are you going to come back? We're not looking necessarily at the merits of the matter. While the main matter is still continuing, on the main matter, what we are guarding against is unreasonable delays. Are the law enforcement agencies doing their work in terms of investigations? How far are they in terms of making sure that their case has been done and dusted? And there's exchange of documents between the two parties. And once they've consulted on those, they come back and say, yes, we are ready for trial. And then a trial date is then elected or appointed. So there's no delay at all. In fact, you can have one dealing with bail proceedings today, and then tomorrow have the main trial dealing with checking the state of readiness of the main trial. It's not going to delay it in any manner.
Khuzeni, we appreciate your time. Thanks so much for coming on tonight and for helping us in this conversation. Yeah, a lot of moving parts there, but certainly we hope we covered much of what was raised in the courts today.